A lot of what we're dealing with today in terms of violating the Constitution, they're doing it through treaties, okay? They're meeting with world leaders. They're in the UN. They're signing this agreement. They're signing that agreement. And the question is, well, wait a minute, where's the Constitution come into play? So we're going to talk about the treaty clause in the Constitution, and we're going to talk about the supremacy clause, because these guys that they sign these treaties and they push these terms down on the American people, and they say, well, you gotta abide by this because treaties are the supreme law of the land. So we're gonna look at that, okay? Now, let me get my glasses on so I can see what I'm doing here. All right, so let's look at the delegation of treaty-making power. It's in Article 2, Section 2. You have your pocket constitutions, you'll find it there. It says, he, the President, shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. Now, what's a treaty? Let's look at Webster's Unabridged Dictionary, 1828. I use the 1828 edition, by the way, because Webster had it in mind when he created the 1828 dictionary that he was going to capture for all posterity the meanings of the words that were used in the founding documents, the Constitution and Declaration of Independence. So here he says a treaty is an agreement, a league or contract between two or more nations or sovereigns, formally signed by the commissioners, properly authorized and solemnly ratified by the several sovereigns or the supreme powers of each state. Treaties are of various kinds. Treaties for regulating commercial intercourse, treaties of alliance, offensive and defensive, treaties for hiring troops, treaties of peace, etc. Okay? I think we all kind of... are there any questions on what a treaty is? I think we all kind of know what a treaty is, right? Okay. So now we need to look at, we know that the President and the Senate are authorized to make treaties, and we know what a treaty is. So now we need to look at the supremacy clause. Okay. So let's suppose that a treaty is lawfully negotiated. The matters involved in the treaty are within the powers of the executive and the Senate. The consent of the Senate is granted. What's the force of the treaty? Does the treaty hold a position of supremacy? In Article 6, Section 2, we're going to find this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So let's pull it apart. There's 4 things that are being named supreme in the supremacy clause, believe it or not. 4 things. Number 1, I'm going to keep these in mind. Number 1, the Constitution shall be the supreme law of the land. Number 2, the laws of the United States shall be the supreme law of the land. You can see if you break this clause, if you break these clauses up, this Constitution shall be the supreme law of the land. The laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. All treaties made, this is the 3rd one, all treaties made, past tense now, shall be the supreme law of the land. And the 4th thing is all treaties which shall be made under the authority of the United States shall be the supreme law of the land. Now, we're going to look at 2 interesting things here. We're going to see that when they talk about laws of the United States, they're talking about in pursuance of the Constitution. But when they talk about treaties, they're talking about treaties made under the authority of the United States. So why do they use pursuant to the Constitution when they're talking about law, and under the authority of the United States when they're talking about treaties. Okay? What they're doing here is, let's put yourself in the position, you're a delegate. You're sitting down, you're writing the Constitution. What is the authority of the United States when you're, as a delegate in 1787? Does anybody know? Anybody? What was the authority of the United States? Yeah. The Articles of Confederation, that's right. The Articles of Confederation preceded the Constitution. The United States was created as an entity via the Articles of Confederation. Now, they're using this language because they want to make sure that treaties that we entered into prior to the Constitution are not going to be violated. They're not going to be canceled as a result of the adoption of the Constitution. Okay? One of those treaties, by the way, was the treaty with Great Britain, which declared the terms of peace in our war for independence. Right? So, they're saying the Constitution is supreme, laws written under the Constitution is supreme, all the treaties that we created under the Articles of Confederation, and even the treaties that we're going to create under the Constitution are all going to be considered supreme. Now, what are they supreme over? Well, here we get to the bottom of this. We get to the bottom here, and we're going to look at these adjectives here. Get my glasses a bit more. So look at the adjectives in this Article 6, Section 2. You can see here they start out using this Constitution. They end up saying the Constitution. Let me get that back. Hold on. Yeah. They end up saying the Constitution, or laws of any state to the contrary notwithstanding. What they are doing here is they are establishing the fact that the treaties and the Constitution and the laws of the United States are supreme over the individual constitutions of the states. They're not saying that the treaty is superseding the Constitution. Okay? You see that? Now, where does this nonsense, where does this idea, this myth that treaties supersede the Constitution come from? We're going to look at some opinions on the matter. The prime opinion that I found, one of the most early references to this idea that treaties supersede the Constitution, comes from a man named John Foster Dulles. So we're going to look at John Foster Dulles, who he was, who his friends were, what kind of influence he had in the United States, etc. Right? And then we're going to look at what he had to say, and then we're going to look at the opinions of the founders. There's three in mind here: Madison, Jefferson, and Hamilton. And then we'll look at a few of the Supreme Court cases that dealt with treaty law. And hopefully, by the time we're done wrapping this thing up, you're going to see that John Foster Dulles was not exactly truthful with the American people, and that he laid down the blueprint as to how the federal government could usurp power from the people in the states using the treaty clause of the Constitution if they were successful in bamboozling American people to accept this concept that treaties supersede the Constitution, which we're going to find they don't. Here we go. Let me catch up here. All right. So, John Foster Dulles. Does anybody know anything about John Foster Dulles? He's been dead for over 55 years. So we're gonna. Why do we need to talk to this guy? Because he's probably, if he's not the inventor of this concept that treaties supersede the Constitution, he certainly is probably the foremost promoter of the concept. He was a Secretary of State under Eisenhower. That's Dwight D. Eisenhower. He went to Princeton University. He attended George Washington University Law School. His grandfather was John W. Foster. Secretary of State under Benjamin Harrison. His uncle Robert Lansing was the Secretary of State under Woodrow Wilson. His brother Allen Dulles was a CIA director, and his sister Eleanor Lansing Dulles worked in the State Department under his brother, she was involved in the economic reconstruction of post-World War II Europe. A pretty powerful slot. Let's see. John Foster Dulles specialized in international law with Sullivan and Cromwell, and he ultimately was made a partner in the firm. I guess you could say he cut his teeth in international affairs when he served as legal counsel at the Versailles Peace Treaty. And if you don't know what the Versailles Peace Treaty is, it was the treaty, it was one of the treaties. There were several treaties. It was one of the treaties, conferences I should say, that was responsible for creating the treaty that ended World War I. Okay? He was a member of the League of Free Nations Association, and he was a founding member. He was a member along with Eleanor Roosevelt, who is a Democrat, right? Her husband was a Democratic president. And so the League of Free Nations Association supported the American membership in the League of Nations, and they later, after the Senate voted down the League of Nations, they changed their name to the Foreign Policy Association. Foreign Policy Association, to my knowledge, is still operating today. Now, in politics, John Foster Dulles was the chief foreign policy advisor to Thomas Dewey. Now, Thomas Dewey is on your way. Thomas Dewey was he was a Republican candidate for president. He ran in both 1944 and 1948. So he lost to Franklin Delano Roosevelt, and he lost to Truman as well. But John Foster Dulles was his chief foreign policy advisor. Now, John Foster Dulles also helped to draft the preamble to the United Nations Charter. So we've had some classes, I think, earlier in this week talking about the United Nations, right? What a trap that was. So here's a guy that was sitting in the conference writing the preamble. He was a U.S. delegate to the UN in 1946, 47, and 50. He strengthened NATO. Remember what NATO is? North Atlantic Treaty Organization, right? That's an umbrella group. It's like a regional alliance. It's under Article 51, I think, of the UN Charter. Check on that. He was the architect of CETO. Anybody hear of CETO? You know what that was? Okay. Oh, okay. Yeah, it's a Southeast Asian treaty organization. That's the regional group that the United States military fought the Vietnam War under. Okay. He also supported a coup d'etat in Iran and in Guatemala. That was during the Eisenhower administration. And he was quoted as saying that neutrality has increasingly become obsolete. It's an immoral and short-sighted conception. So you get an idea. This guy is an interventionist. Now, he was a chairman and co-founder of the Commission on a Just and Durable Peace. That was some kind of like a working group within the Federal Council of Churches, okay? And the Federal Council of Churches became the National Council of Churches. And that's still, that's a member of the World Council of Churches today, right? He was the chairman of the board of Carnegie Endowment for International Peace, trustee of the Rockefeller Foundation from 1935 to 1952. He was a founding member of the Foreign Policy Association, we mentioned it earlier, and he was a founding member of the Council on Foreign Relations. So this guy's pretty heavy into it, heavyweight. All right, so why are we talking about him? Here's his quotes. He delivered a speech. In front of the American Bar Association's the American Bar Association chapter in Kentucky, in Louisville, Kentucky in 1952. Okay? When he was in that meeting, he made the following statement. He said, "The treaty-making power is an extraordinary power liable to abuse. Treaties make international law and they make domestic law. Under our Constitution, treaties become the supreme law of the land. They are indeed more supreme than ordinary laws, for congressional laws are invalid if they do not conform to the Constitution, whereas treaty laws are invalid if they do, treaty laws can override the Constitution. Treaties, for example, can take powers away from Congress and give them to the President. They can take powers from the state and give them to the federal government or to some international body, and they can cut across the rights given to the people by the Constitutional Bill of Rights." Just about everything he said here is a lie. And I say it's a lie not because what he says is false, but because he knows better. Okay? I mean, this guy is a Princeton graduate, right? He went to Washington University. He's hobnobbing with all these big wigs in international affairs. He's a lawyer. He knows this is false. He has to. James Madison. Here's what James Madison has to say about it. He says, "I do not conceive that power is given to the President and the Senate to dismember the empire or alienate any great essential right. I do not think the whole legislative authority have this power. The exercise of the power must be consistent with the object of the delegation." We're going to move on to Thomas Jefferson. All right. Thomas Jefferson says that by the general power to make treaties, the Constitution must have intended to comprehend only those objects which are usually regulated by treaty and cannot be otherwise regulated. Okay? So he's saying, look, you know, you can't just regulate anything through a treaty. Okay? He says, "It must have meant to accept out of those the rights reserved to the states, for surely the President and Senate cannot do by treaty what the whole government is interdicted from doing in any way." Okay? One more time. Jefferson says, "I say the same as to the opinion of those who consider the grant of treaty-making power as boundless. If it is, then we have no Constitution." In other words, if there's no limit on treaties, then you could just change the whole government through treaty law, right? Alexander Hamilton, he said that the only constitutional exception to the power of making treaties is that it shall not change the Constitution. On natural principles, a treaty which should manifestly betray or sacrifice primary interests of the state is null, or would be null. Okay, so this is a direct refutation of John Foster Dulles, who said that, you know, treaty law can change the Constitution, right? Here's another quote by Hamilton. He says, "A treaty cannot be made which alters the Constitution of the country or which infringes any express exceptions to the powers of the Constitution of the United States." Okay? Now, we'll look at a couple of Supreme Court decisions here. The first one here is Reed v. Covert, and it's let's see if we can find some information about the details of this thing here. I lost my, there it is. Okay, good. Okay, this case dealt with two women charged in the murder of their husbands. Okay? And the husbands were in active service overseas. So the military attempted to try the cases in military tribunals and stripped the defendants of their protected rights under the Constitution. The military cited treaty law and congressional law in the form of the Military Code of Conduct. After quoting the Supremacy Clause in Article 6, here's what the court said. "There is nothing in this language which intimates that treaties and laws enacted pursuant to them do not have to comply with the provisions of the Constitution. Nor is there anything in the debates which accompanied the drafting and ratification of the Constitution which even suggests such a result. The prohibitions of the Constitution were designed to apply to all branches of the national government, and they cannot be nullified by the executive or by the executive and the Senate combined. Okay? All right, now we got Jeffrey versus Riggs. This one is from 1890, and the case involved the inheritance of land by French citizens situated in Washington, D.C. The land was left in part to nephews and nieces of the deceased, and the estate was going to be shared amongst French and U.S. citizens. So there was some conflict over this. And the Supreme Court, what we're interested in is not what happened to the land. We're interested in what the Supreme Court's opinion was with regard to the treaty law. Okay? So when the opinion came down, the Supreme Court said that the treaty power as expressed in the Constitution is in terms unlimited except by those restraints which are found in that instrument against the actions of the government or of its departments, and those arising from the nature of the government itself and of that of the states. So it would not be contended that it extends so far as to authorize what the Constitution forbids. For a change in the character of the government or in that of one of the states, or a cession of any portion of the territory of the latter without its consent. Okay. So here, the court is saying there are limits on treaties, right? And that the Constitution itself is part of that limit. Okay. So the last court case we want to look at is Whitney versus Robertson, and this was in 1888. And this case involved the payment of duties for imported goods from the Dominican Republic. And so the tax was upheld by the court because the tax acts of the Congress were more recent than the treaty cited against them. Okay, so let's take a look at this one. This is a knockout punch. The Supreme Court says that by the Constitution, a treaty is placed on the same footing and made of like obligation with an act of legislation. Both are declared by the instrument to be the supreme law of the land, and no superior efficacy is given to either over the other. If the two are inconsistent, the one with lasting date will control the other. So the courts are saying a simple act, a legislative act of law under the Constitution by the Congress can override a treaty, because law under the Constitution is also supreme. Okay? Got it? So let's go back and look at John Foster Dulles again. Let's see how we feel about this statement one more time. Now let's look at what the motives of John Foster Dulles might have been while we're at it. So here he is. The treaty-making power is an extraordinary power liable to abuse. Is that true? Treaties make international law and they make domestic law. Is that true? Under our Constitution, treaties become the supreme law of the land. Are they more supreme than ordinary laws? I think we just found that they're not, right? Clearly, the opinions of our framers and founders are at odds with John Foster Dulles. And the Supreme Court rulings have also been at odds with John Foster Dulles. So why did he hold these erroneous positions? I suggest that one could tell a great deal about another by examining his friends and associates rather than expressing his honest beliefs. I believe that Dulles' statement in 1952 was actually a veiled battle plan against the Constitution. I think his quote was certainly aimed at misleading the members of the Bar Association. However, it may have been a message to his friends and associates and like-minded people as to the methods which needed to be employed in order to promote international law over that of the U.S. Constitution. If we look at his quote, we can see 9 specific statements that he outlines. We're going to look at that real quick here. Okay. He says the treaties make international law. He says that they make domestic law. He declares that they're supreme law of the land regardless of their legitimacy. He declares that treaties are more supreme than ordinary laws. He says they write laws that override or alter the Constitution. He says they can strip powers away from the Congress and concentrate the power in the President. He says they can strip powers away from the state and concentrate the power in the federal government. He says they can strip powers away from the state and concentrate that power in a world government. And he says they strip the inalienable rights of the people by weakening and canceling the Bill of Rights. So, I mean, you know, the very fact that he will stand here and he will use this language here, I'm going to highlight this for you. Take a look at this. And if I can, no, I can't highlight it. All right, take a look at this. Cut across the rights given to the people by the Constitution Bill of Rights. Did the Constitutional Bill of Rights give the people any rights?
No.
No, it didn't, right? Who gave us our rights? That's right. God gave us our rights, and the Constitution, the Bill of Rights, simply guarantees those rights. We can see just to what lengths this man goes. All right. So let's take a look at how these 9 points that we've discussed are actually playing out today, right? Because these 9 attacks, I would say that they're still in play in 2016, 57 years later or whatever it is, okay? So, use treaties to make international law. Are they doing that today? If we take a look at Article 102 of the United Nations Charter, which appears under Chapter 16, miscellaneous provisions, demonstrates an attempt to register treaties as binding international law. Okay? It also seeks to place the United Nations above sovereign nations as the arbiter of international law. According to the U.S. State Department document, there's a document called Treaties in Force. Okay, let's see if I got something on this. There it is. Okay. U.S. State Department Treaties in Force. There are bilateral treaties, 324 pages, 3 columns of bilateral treaties that the U.S. is involved in there. There's 170 plus pages of multinational treaties. The table of contents of this document takes 4 pages and real tiny, I'm telling you, it's really tiny print. You got to get a magnifying glass out. You're over 30 to read this thing. It's got an additional addendum that was created in 2014-15. So that would be, you know, the federal government's calendar starts in September. So it's September 2014 through, August of 2015. They issued 80 pages of addendum. My point is we're tying ourselves into all these international agreements through treaties. Okay. Step 2. This is still Dulles here, right? His second idea is we're going to make or alter domestic law through treaties. So are they doing that? Well, if we look at some of these groups like the WTO, do you know what that is? That's a World Trade Organization, right? World Trade Organization, we got GATT, that's the General Agreement on Tariffs and Treaties. NAFTA, that's a big one everybody knows, North American Free Trade Agreement. We've got a couple new ones, TPP, what's that, Trans-Pacific Partnership, I believe, and the TTIP. The, what is that? That's the Transatlantic Trade and Investment Partnership, thank you. And then, of course, we've got the climate change agreements through Agenda 21. We've got UN Small Arms Treaty, which is directly attacking the Second Amendment. And we've got the patent law treaties. And I should take a couple seconds to talk about the patent law treaties. The U.S. patent law is much different than the rest of the world. In the United States, traditionally, if you were the first to come up with an idea, you owned it, right? In a lot of other nations, it all has to do with the date at which you register your idea with the government, okay? So, you're going to find a lot of like small investors, small inventors are having their patents and their copyrights taken from them by big bureaucracies that have the legal team to go ahead and beat them to the punch, as it were, to register these ideas. Okay, so that's an interesting little quirk that a lot of people will overlook, this patent law thing. Okay. Excuse me. Also, Dulles, he says that treaties are the supreme law of the land. And in brief, the fact that all the foreign relations powers, this is I'm sorry, let me introduce this quote. This comes from the CRS Annotated Constitution. It's Cornell University's Law School, Cornell University Law School's Legal Information Institute, LII. This is what they're teaching our new lawyers. It says, in brief, the fact that all the foreign relations power is vested in the national government and that no formal restrictions is imposed on the treaty-making power in the international context. They always make a distinction between domestic context and the international context. 15 minutes, thank you. Making power in the international context leaves little room for the notion of a limited treaty-making power with regard to the reserve rights of the states or in regard to the choice of matters concerning which the federal government may treat with other nations. Protected individual rights appear to be sheltered by specific constitutional guarantees from the domestic effects of treaties, and the separation of powers at the federal level may require legislative action to give municipal effect to the international agreements. What does all this mean? Okay, this is for lawyers, right? What does all this mean? I'll boil it down for you. Okay, well, what they're saying is that Cornell's teaching our future lawyers that all foreign powers are in the federal government's domain, that the states' rights don't matter, and there are no restrictions on the subjects which may be addressed via treaties, and that individuals' unalienable rights can be canceled as long as the Congress passes what they call domestic enabling legislation. Now, you start to understand why our legislature, which is mostly lawyers, allows this insanity to continue. Right? Step 4, we're supposed to. He wants his friends to declare treaties more supreme than other laws. We've already talked about this, but if you look at what they're doing here, they're the idea that treaties are more supreme than other laws is really primarily done by agreements among nations on matters which are traditionally domestic. Okay? Crime, the environment, arms and ammunition, food and agriculture. Okay? These are things that are typically regulated by a nation through its legislative branch, not through treaties. Now, I need to introduce this guy to you real quickly, too, before we end this talk. This guy here, this is Frederick L. Kurgis. He wrote something called Treaties as Binding International Obligations. And he's considered the foremost authority in international law. He provides a new understanding of treaty-making power to law students in both the United States and in Europe, the UK in particular. Okay? So he says the definition of a treaty for international law purposes is broader than one finds in the U.S. Constitution. Where treaties are defined as domestic law, as international agreements entered into with the advice and consent of 2/3 of the Senate, it is widely accepted that the United States may enter into some international agreements that are treaties in the international sense, but not in the U.S. constitutional sense. Some of those agreements are entered into by the executive branch on its own authority, and some by the executive with the concurrence of both houses of Congress. So I don't know where he gets this from. This is unbelievable. Okay? This is what they're selling our law students. Now, Professor Kurgis attempts to draw a distinction between the domestic effects of treaties and the international effects of treaties. In doing so, he infuses new meaning into Article 6 of the Constitution. He invents two new ratification processes for treaties, the latter of which is in use via free trade agreements, and it's highly irregular. You see here, he says, some of these agreements are entered into by the executive branch on its own authority, and some with the executive with the concurrence of both houses of Congress. Every time we see a new trade bill come down the pike, right, this TTIP and this TTP, they're not passing them as treaties requiring 2/3 consent of the Senate. They're negotiating with with whatever nations are involved in these regional groups, and then they're putting it in front of the Congress. Both houses are putting it in front of the House of Representatives and the Senate, and they're doing it via standard 51% approval, and bang, they're passing them as if they were standard laws. So there's really no legitimate way to do some of these multinational trade laws that they're doing, because the Congress in the House of Representatives has a role to play in regulating commerce, right? So they're trying to do that, which is not legitimate in a constitutional sense, and they don't really have a proper vehicle. There's no real proper constitutional process to do what they want to do, so they just lie. They just say, well, some treaties in the international sense can be entered into, by the President and both houses of Congress. Step 6, the Dulles statement wants to strip power away from the Congress and concentrate the power in the President. We see that specifically today in what's called TPA. Anybody heard of TPA before? TPA is the trade, say again? Who said that?
Fast track.
Fast track, that's right. Trade Promotion Authority, fast track, right? So that started in the mid-1970s. What it does is, what Trade Promotion Authority does is, it gives the President of the United States legislative power. It allows him to set the terms of certain agreements, and then when it's presented to the Congress can't really debate it properly, they can't really amend it properly, they have to fast track it, and it basically converts the President into a quasi-legislator. Now we know when we read Article 1, Section 1 of the Constitution, it says all legislative powers herein granted are reserved to a Congress, right? And here we've got the President, he's going to become a legislator through TPA. So it's clearly unconstitutional, but they do it and we let them get away with it. Power is stripped away from the states. How does that happen? Well, anytime they create these treaties that cover what are considered domestic issues, like gun legislation or some kind of trade, commerce, whatever, right? So when they do that, then they go to the states and they say, well, treaties are the supreme law of land, so you got to line up and comply. Okay, so they end up transferring power from the states into the federal government in that way. How much time I got? 5 minutes, thank you. So we're going to wrap this up. What are we going to do? What are we going to do about this? So I'm going to give a few suggestions on what we can do to mitigate some of this treaty, what I would call, what I call it treason, basically, through treaty. And what we're going to do, we're going to discuss this with our neighbors, for sure. What we need to do is we need to make sure that all of our legislators understand, at every level, understand that treaties do not supersede the Constitution. Okay? Treaties are within the Constitution. We need to cancel a lot of existing treaties. Treaties that are violating our Constitution right now, they need to get canceled. And if the President and the Senate won't do it, well, we found out when we were looking at the Supreme Court cases that the Congress can write a simple piece of legislation to cancel a treaty, right? So let's do that. Let's get our congressmen to cancel. Let's start with, here you go. Let's start with get us out of the UN. How's that? We can put a nail right in the coffin of world government. There is a bill, H.R. 1205, the American Restoration Act, the American Sovereignty Restoration Act, that would get us out of the United Nations. It'll do that by defunding the UN. Some other resources for you. I have a blog at federalexpression.wordpress.com. There's a YouTube video out there that Jonathan McManus did in the early 90s, I believe, called Revolution by Treaty, in which he touches on some of these issues from a different perspective. You can look at this video. We'll make sure we get this presentation posted up on the YouTube channel. You can relook at this. We have Treaties and the Constitution by George C. Detweiler. And the Constitution versus UN Arms Treaty. That's put out by the 10th Amendment Center. They have a website and a YouTube channel. Okay, and the rest of this is my resources. So, okay.